Hi folks, and welcome back to Conveyancing. This is the video series for formation of contract, and we are now up to module 2. You will recall in the last couple of videos that we had a look at in this series for formation of contract, we had a look at the requirements of the Property Law Act for a contract to be properly constituted and valid and enforceable under that legislation. Today, as you can see, we are having a look at what I think I rather inelegantly called a ragtag bunch of other stuff related to formation of contract in the last video series. So today we are at the happy position of having formed our contract. It seems to be valid under the PLA. What's the next issue that you'd need to start thinking about? Well, that would be the cooling off period under which the buyer can back out of the transaction. Then the other thing we need to think about is instalment contracts, and it's in a little red circle for a reason. Quite often these kinds of contracts are not entered into in a designed sense, that is not a planned sense, they just kind of happen, which is rather unfortunate because of the restrictions that flow with installment contracts. So we need to have a look at that. Then we need to look at prohibited transactions. So even if all else seems to be good, the buyer hasn't backed out and used the cooling off period as not an installment contract, well, what about the snags that you can hit later on down the track when you find out that the transaction may well be prohibited by other legislation? Then if you clear that hurdle, all seems to be green lights, then the last thing that you need to think about is the deposit. So that is where we're going today. So the first thing we need to look at is the cooling off period. So if we zoom in through the desert, we arrive at our large orange slide, and that is very orange and it's probably hurting your eyes, so I'm sorry about that. We can see that we need to look at two main things, which is the structure of the cooling off provisions and calculation of time, and also finally really what happens when you don't comply. So firstly, I wanted to take you to the provision in the REIQ contract. This is in the reference schedule, and you can see this. Good old Lord Denning's red hand is kind of where the arrow is. You couldn't get it any more conspicuous, this warning notification, designedly so, and you'll see why in a minute. And it's under the requirements of the legislation that it appears like this. But the warning says the contract may be subject to a 5 business day statutory cooling off period, termination penalty of 0.25% of the purchase price applies if the buyer terminates the contract during the statutory cooling off period. It's recommended the buyer obtain an independent property valuation and independent legal advice about the contract and his or her cooling off rights before signing. I would say it's probably more the exception than the rule. I don't know of anybody that gets legal advice on cooling off rights before signing. Everyone's usually too eager, and that's probably where half the problems stem from. But that's the content of the warning, and as you can see, placed smack bang right above where the buyer has to sign. So there's little chance that the buyer will be able to escape noticing that warning statement. So if you want to cool your heels, don't you like that little clip art there? Then that is the warning notification that will tell you what your rights are. So what is this regime that sets up the cooling off period for buyers? It is none other than the Property Occupations Act, which we have come into contact with a couple of times before in this unit. Section 160 is the provision that shows you what contracts need to include the warning statement. As you can see, sub 1 there, contract including a contract granting an option to purchase, that is a relevant contract for the sale of residential property. Doesn't include a whole stack of stuff. Then you come to section 165, which tells you who is responsible for getting the warning into the contract, and you can see the text of the warning set out in sub 2 there that we just saw gets transposed into the REIQ standard form contract there. As you see, sub 3, the seller has to ensure the words are written in the contract once immediately above on the same page as the contract where the buyer signs. Sub 2, it says the words have to be conspicuously written. So that is why we had the bold type in the REIQ contract. So let's have a look at the components of, that orange just hit me in the eye again. Let's have a look at the components of 160 and 165 just so that we're sure about the legislative underpinnings for all of this. So the first thing we need is a relevant contract. So section 160 says, and that is a contract for the sale of residential property. In terms of what falls within what the legislation contemplates as a contract, gives us a little idea. It says it includes an option to purchase. So clearly it's not just the good old garden variety contract, it's also more technical agreements like options to purchase. The text goes into a bit of a discussion about whether the current definition of relevant contract would include put options as well, so you can have call options. That is where you have an agreement that allows one of the parties to call for the sale of the property to them. You can also have a put option, which is the kind of flip scenario where one of the parties has the right to put the sale of a property to the other person. Often you will have them combined, so you will have a put and call option, so both of the parties have the right to elect to exercise their rights or not at some point in the future. Definitely we know that call options are included. Question mark about whether or not it includes put and call options as a package. There's cases, as you can see, the K is my little shorthand for contract. In terms of put options, you can have put and call options. You can have a contract being formed without the exercise technically of a right to purchase. So on one view, perhaps put and call options fall outside of the definition of relevant contract. However, it would probably still be a contract for the sale of residential property in a more broad brush interpretation approach. Like I said, we've got cases going one way, cases going the other way. That's the only issue there. There's a little bit of a question mark about put and call options. Obviously, those contracts need to be for the sale of residential property. Section 21 defines residential property as property that's used or intended to be used for residential purposes. Doesn't include real property that's used primarily for the purposes of industry, commerce, or primary production. There's no definition of residential purposes, but it's reasonably clear what that stuff includes. So, land and a residence on there, land and multiple residences on there, vacant land on which residences may be built. The exclusions at the tail end of that definition has to be used primarily for purposes of industry, commerce, or primary production. In terms of what constitutes primary use for those other purposes, the grey and mercantile mutual case assists there. That is not a real property case, but it is a case that assists with interpretation of the word primarily. They came down on the side of mainly or chiefly. It's the usual contract kind of assessment, objective assessment. You're going to be looking at quantitative, so how much of the property is used for this kind of purpose. It's a common sense approach at the end of the day. So that's contracts for the sale of residential property. Then, as you saw, there's a stack of exclusions from what will constitute a relevant contract. Contracts formed at auction will not have to comply with the section 165 notice of cooling off period. contracts entered into after auction with the registered bidders. So, for example, where there has been a fall of the hammer, but the property's been passed in, and then you have that marvelously frenetic period where the auctioneer is running around to all the registered bidders that showed some interest in the property, trying to generate a contract. Those contracts you don't have to worry about. Section 165, known as a contract formed. No exercise. There should be on exercise of the option between the same parties. So remember, we were talking about call options and the ability of one of the parties to that option agreement being able to elect to exercise their rights to purchase the property. That subsequent agreement between those two same parties that gets formed when one of them exercises that right to have the transaction concluded, that subsequent contract also is excluded from the requirement to have to put in a cooling off period notice. Where the buyer is a publicly listed company or subsidiary, the state, statutory authority, or where you've got lots being purchased in a large number. All fairly sensible exclusions from relevant contract. The purchasers under those situations will more than likely know what their rights are. They don't need a cooling off period, a notice of a cooling off period, put it that way. So we know what the contract warning says. We've had a little look at it in the REIQ contract. What happens if you don't comply? Well, the buyer can't terminate, unfortunately for them, but the seller may well cop a fairly sizable fine of anywhere up to $26,500. So fairly good incentive to comply there. What about when the cooling off period starts and finishes? Well, you've got 5 business days once the cooling off period starts. If you want to exercise the cooling off period as a buyer, it has to be done obviously by written signed notice served on the seller or their agent. You will have to still pay your 0.25% termination fee, although obviously that's a lot more preferable than having to lose the whole of your deposit. The seller can take the termination fee out of your deposit, but they have to refund the rest of your deposit back to you as buyer within 14 days. When does all of this happen? The cooling off period, as I say on the slide there, first bullet point, starts on the day the buyer receives the contract into their hot little hands that has been assigned by both of the parties, or the first business day thereafter. So if you have received on a Monday, if the buyer has received a contract signed by both parties, then the cooling off will finish at 5 p.m. on the Friday. Similarly, if they have received the contract on the weekend, either Saturday or Sunday, then it's going to start again Monday, and it will finish again at 5 p.m. on the Friday. If there are multiple buyers, and this is something that the text just says to be careful of, you probably should serve a copy on each of the buyers to avoid any delay, because you're going to have all of the buyers being in receipt of the signed contract, or a copy of the signed contract signed up by everybody, and time will start ticking then. So they say, just to protect your client, if you're acting for a seller, get a copy to everyone that's involved. The onus of proving receipt falls on the seller, and the text goes into a bit of a discussion about when a seller can be kind of quite sure that they have sufficient evidence to prove receipt. Obviously, it's going to be pretty easy if you've got personal service, you're actually handing over the contract to the other party. What you need to get your agent to do is actually get a signed acknowledgement that that's when the contract was provided to the buyer. Post, we don't have a postal acceptance rule here, so the text seems to think maybe best not to actually post a copy of the signed contract off to the buyer, because you can't really be certain what day that they're actually going to receive the thing and when the cooling off period is going to start ticking. For fax, email and those kinds of electronic transactions, you'll be covered by the ETA, and as you'll recall from your contract law days, the ETA will deem receipt of an electronic communication slightly differently depending on whether the person receiving the communication has nominated an address to be contacted at electronically or not. If they have not, but the communication is sent to them anyway, then basically they're not going to be deemed to have received it until it's been read. If they have nominated an address to be contacted at electronically, then they will be deemed to have received the communication once basically it gets to their server. So that's the situation for electronic communications. Under section 166 sub 2, this is just an eminently sensible provision. If the buyer signs basically immediately after the seller, they're going to be deemed to have received upon signing and communicating their acceptance to the seller. So essentially, and this will apply in most situations where you've got some argy-bargy going on between the buyer and seller, there's backwards and forwards, counter offers are being swapped, and then the seller says, this is my lowest price, countersigns at that price, the agent takes it back to the buyer also countersigns at the same price. Once the buyer then says to the agent, and the agent communicates this to the seller, that the buyer is signed off, that's when the clock will start ticking under 166 sub 2. So that is how you calculate when your cooling off period is going to start. And we've hit the magical 15-minute mark, so I'll leave it here for this video. We'll go to the next video to have a look at installment contracts. So bye for now, folks.